Hello everyone, welcome to my business law lecture series. In this class we are going to study classification of contract based on validity, creation and performance. Before that, let us have a small recap of our previous classes. So in the previous classes we learned regarding essentials of a valid contract, in which we have covered all the 10 basic requirements for a valid contract. So start with basis for classification of contract. So based on 3 criteria, we have classified the contract: validity, creation and performance. Based on validity, how much it's valid or how we can consider the contract. So here valid contract, void contract and voidable contract. Second one, creation of contract. ನಾವು ಹೇಗೆ ಕಾಂಟ್ರಾಕ್ಟ್ ಅನ್ನು ಕ್ರಿಯೇಟ್ ಮಾಡಿಕೊಳ್ತೇವೆ. ಆಫರ್ ಅಂಡ್ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಯಾವ ಫಾರ್ಮ್ ಅಲ್ಲಿ ಆಗ್ತದೆ ಕಾಂಟ್ರಾಕ್ಟ್, ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಿ ನಾವು ಕಾಂಟ್ರಾಕ್ಟ್ ಅನ್ನು ಕ್ಯಾಟಗರಿ ಮಾಡ್ಕೊಳ್ತೇವೆ. ಅಂಡ್ ಬೇಸ್ಡ್ ಆನ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್, ಕಾಂಟ್ರಾಕ್ಟ್ ಫಂಕ್ಷನ್ಸ್ ಗಳನ್ನ, ಟರ್ಮ್ಸ್ ಗಳನ್ನ ಎಕ್ಸಿಕ್ಯೂಟ್ ಅನ್ನ ಏನ್ ಮಾಡ್ತೇವೆ, ಬೇಸ್ಡ್ ಆನ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ವಿ ಹ್ಯಾವ್ ಕನ್ಸಿಡರ್ಡ್ ದ ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಆಫ್ ಕಾಂಟ್ರಾಕ್ಟ್. Let us see little bit a detailed version based on validity. So here 3 category: valid, void and voidable contract. So based on validity means validity here indicates whether it is legally enforceable or not. ನಾವು ಆ ಪರ್ಟಿಕ್ಯುಲರ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಅನ್ನ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕ್ಲೈಮ್ ಮಾಡಬಹುದು ಇಲ್ವೋ ಅದರ ಬೇಸಿಸ್ ಅಲ್ಲಿ ನಾವು ವ್ಯಾಲಿಡ್ ಮತ್ತೆ ವಾಯ್ಡಬಲ್ ಅಂತ ಹೇಳಿ ಕ್ಯಾಟಗರಿ ಮಾಡ್ಕೊಳ್ತಾ ಹೋಗ್ತೇವೆ. ಸೊ ಫಸ್ಟ್ ಒಂದು ವ್ಯಾಲಿಡ್ ಕಾಂಟ್ರಾಕ್ಟ್, which is it's very simple, which satisfy all the legal requirements of a contract if it fulfill all the 10 criteria of a essentials of contract. So those contract can be considered as a valid contract. And second one, void contract. In this case, contract ceases to be enforceable by law. Contract created, but after some time it becomes void, that means which cannot be enforceable by law. For example, the contract between A and B, or contract between A and B for a sale of goods, but after some time Mr. B died. In that situation, contract become void because it cannot be legally enforceable, which ceases to be enforceable by law. Next one, voidable contract. Contract enforceable at the option of one or more of the parties, but not at the option of others. For example, a contract like a partnership between A, B and C. In this particular case, Mr. B retires from partnership. So here only 2 persons, A and B, will remain in the partnership form. It is at the option of these A and B either to continue the partnership form or to drop. So for that reason it is considered as voidable, which means the contract may be termed as void or they can continue it as a valid contract, but this option is in the hands of contracting parties. So it is voidable. And the second criteria for classification was formation. How we are going to create the contract, whether it is in writing or it may be in oral, like that. So in the form of creation we have classified. So these classifications are express contract, implied contract, mixed contract and quasi contract. The first one, express contract. As the name indicates, a contract made in writing or in vocal words. Express contract ಅಲ್ಲಿ ಕಾಂಟ್ರಾಕ್ಟಿಂಗ್ ಪಾರ್ಟೀಸ್ ಏನಿದ್ದಾರೆ ಆ ಪಾರ್ಟೀಸ್ ನ ಮಧ್ಯೆ ಎಕ್ಸ್ಪ್ರೆಸ್ ರೈಟಿಂಗ್ ಅಲ್ಲಿ ಅಥವಾ ಇನ್ ವರ್ಡ್ಸ್ ಅಲ್ಲಿ ಆ ಕಾಂಟ್ರಾಕ್ಟ್ ಅನ್ನ ಎಂಟರ್ ಆಗಿರೋದಕ್ಕೆ ಪ್ರೂಫ್ಸ್ ಇರ್ತದೆ. ಅವರು ಆ ವರ್ಡ್ಸ್ ಗಳನ್ನ ಯೂಸ್ ಮಾಡಿರ್ತಾರೆ, ಎಂಟರಿಂಗ್ ಇನ್ ಟು ಕಾಂಟ್ರಾಕ್ಟ್. So in such situation there is express contract. In some cases it's implied contract. So contract is one in which contract is one which is inferred from the acts of the parties. So here you should remember the term acts of the parties and the course of dealing to the contract. For example, ನೀವೊಂದು ಆಟೋ ರಿಕ್ಷಾನ ಹತ್ಕೊಳ್ತೀರಾ. ಆಟೋ ಹತ್ತಿದ ನಂತರ ನಿಮ್ಗೆ ಯಾವುದೇ ತರಹದ ರೆಸೀಟ್ಸ್ ಅನ್ನ ಆಟೋದಲ್ಲಿ ಕೊಡೋದಿಲ್ಲ. ಬಟ್ ಸ್ಟಿಲ್ ನಿಮ್ಮ ಆಕ್ಟ್ ಎಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು ಅಷ್ಟು ಮಾತ್ರ ನೀವು ಹೇಳ್ತೀರಾ. ಅದರ ನಂತರ ಅಗ್ರಿಮೆಂಟ್ ಏನಿದೆ, ನೀವು ಎಲ್ಲಿಗೆ ತಲುಪಬೇಕು, ಯಾವ ಪ್ಲೇಸ್ಗೆ ತಲುಪಬೇಕು, ಅಲ್ಲಿಗೆ ತಲುಪಿಸುವಂಥದ್ದು ಅವರ ಜವಾಬ್ದಾರಿ ಆಗಿರ್ತದೆ. ಸೊ there is a contract between the traveler and the auto driver. So here there is no occur words or in the agreement is in writing, but still the agreement or the contract is there, and such contracts are called as implied contract. And third one, mixed contract. The combination of express and implied contract in the process of offer and acceptance of the contract. So maybe the offer is in the form of express contract and the acceptance may be implied. So let's say it's the combination of express and implied contract. And the fourth one is completely different, quasi-contract. Of course, we are going to learn these concepts a little bit lengthier form a little later. But here, obligation created by law based on the principles of equity, justice and fairness. In this particular case, the contract is not entered by the parties. For example, ನಾನು ನನ್ನ ಲ್ಯಾಪ್ಟಾಪ್ ಅನ್ನು ಕಳ್ಕೊಂಡಿದ್ದೇನೆ. ಇದನ್ನ ಅಕ್ಷತ ಅವರಿಗೆ ಆ ಲ್ಯಾಪ್ಟಾಪ್ ಅನ್ನು ಸಿಕ್ಕಿದೆ ಅವರಿಗೆ, ಫೈಂಡರ್ ಆಫ್ ಲಾಸ್ಟ್ ಗೂಡ್ಸ್. ಇನ್ ದಿಸ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಕೇಸ್ ಅಕ್ಷತ ಮತ್ತು ನನಗೆ ಯಾವುದೇ ರೀತಿಯಾದಂತಹ ಡೈರೆಕ್ಟ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಅಥವಾ ಅಗ್ರಿಮೆಂಟ್ಸ್ ಇಲ್ಲ. ಬಟ್ ಅಕ್ಷತ ಅವರ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ ಏನಿರ್ತದೆ ಅದನ್ನು ಡಿಫೈನ್ ಮಾಡ್ತದೆ ಕ್ವಾಸಿ ಕಾಂಟ್ರಾಕ್ಟ್ ಅಂತ ಹೇಳಿ, ಬೇಸ್ಡ್ ಆನ್ ದ ಪ್ರಿನ್ಸಿಪಲ್ಸ್ ಆಫ್ ಈಕ್ವಿಟಿ, ಜಸ್ಟಿಸ್ ಅಂಡ್ ಫೇರ್ನೆಸ್. Even though she got this laptop, she has to return this laptop to the original owner of the goods. So that is the case in case of finder of lost goods. ಇದು ಒಂದು ಎಕ್ಸಾಂಪಲ್ ಕ್ವಾಸಿ ಕಾಂಟ್ರಾಕ್ಟಿಗೆ. ಇದರಲ್ಲಿ ಕಾಂಟ್ರಾಕ್ಟಿಂಗ್ ಪಾರ್ಟೀಸ್ಗಳು ಯಾವುದೇ ರೀತಿಯಾಗಿ ಅಗ್ರಿಮೆಂಟ್ಸ್ಗಳನ್ನ ಮಾಡ್ಕೊಳ್ಳೋದಿಲ್ಲ, ಐದರ್ ಎಕ್ಸ್ಪ್ರೆಸ್ ಆರ್ ಇಂಪ್ಲೈಡ್. ಬಟ್ ಸ್ಟಿಲ್ law will define the obligations and rights. In such cases, we are going to call it as quasi-contract. An example for quasi-contract is finder of lost goods. ಅಲ್ಲಿ ಯಾವುದೇ ರೀತಿಯಾದಂಥ ಅಗ್ರಿಮೆಂಟ್ಸ್ಗಳು ಇಲ್ಲದೆ ಇದ್ರೂ ಕೂಡ ರೈಟ್ಸ್ ಮತ್ತೆ ಆಬ್ಲಿಗೇಷನ್ಸ್ಗಳು ಫಾರ್ಮ್ ಆಗ್ತದೆ ಬೇಸ್ಡ್ ಆನ್ ಕಾಂಟ್ರಾಕ್ಟ್. ಸೊ ಫಾರ್ ದಟ್ ರೀಸನ್ ಇಸ್ ಕಾಲ್ಡ್ ಆಸ್ quasi-contract. Quasi-contract created by law and not by business parties. Last one, classification based on performance or execution. So here, executed contract. The contract is already over. All the terms and conditions mentioned in the agreement or contract has been completely performed. The bridge constructions ಗೆ ಕಾಂಟ್ರಾಕ್ಟ್ ಆಗಿತ್ತು ಲಾಸ್ಟ್ ಇಯರ್. ಆ ಬ್ರಿಡ್ಜ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ವರ್ಕ್ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ, ಅವರಿಗೆ ಪೇಮೆಂಟ್ ಕೂಡ ಮಾಡಿ ಆಗಿದೆ. The entire contract is over. So for that reason, it's executed contract. Executory contract. Contract in which both the parties haven't performed their respective promises wholly. So here, contract has been formed, but neither of the party have started their respective work. For example, of course, ಬ್ರಿಡ್ಜ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಟೆಂಡರ್ ಅನ್ನು ಕರೆದಿದ್ದೇವೆ, ಟೆಂಡರ್ ಸೆಲೆಕ್ಷನ್ಸ್ ಆಗಿದೆ. ಬಟ್ ನೈದರ್ ದ ಪೇಮೆಂಟ್ ಇಸ್ ಮೇಡ್ ನಾಟ್ ದ ವರ್ಕ್ ಸ್ಟಾರ್ಟೆಡ್. ಪೇಮೆಂಟ್ ಕೂಡ ಆಗಲಿಲ್ಲ, ವರ್ಕ್ ಕೂಡ ಸ್ಟಾರ್ಟ್ ಆಗಲಿಲ್ಲ, ಬಟ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಫಾರ್ಮ್ ಆಗಿದೆ. ಸೊ ದೋಸ್ ಕಾಂಟ್ರಾಕ್ಟ್ಸ್ ಆರ್ ಕಾಲ್ಡ್ ಎಕ್ಸಿಕ್ಯೂಟರಿ ಕಾಂಟ್ರಾಕ್ಟ್. ಕಾಂಟ್ರಾಕ್ಟ್ಸ್ yet to start. Partly executed contracts. Contract in which one or both the parties to contract have not fully performed their respective promise. So here, partly executed contract. So here, the possibilities are two. Either both the parties have performed their part of work partially, or one party has performed his part of work completely and the another portion is pending. For example, bridge construction work. Constructions ಮುಗ್ದಿದೆ but payment ಮಾಡಲಿಲ್ಲ. Partly executed. One party has completed the work but another party haven't completed the work, haven't did the things. Otherwise, bridge constructions work ಒಂದು portions ಆಗಿದೆ but complete ಆಗಲಿಲ್ಲ work. Again the payment partly made, not complete payment is made. So in that situations also is called as partly executed contract. So here there are some different terms in association with the classification of contract. So here we should be clear regarding these terms. So the first one, void agreement and void contract. So void agreement means an agreement which is not enforceable by law. Yes, an agreement which is not enforceable by law. Before that, I like to make you clear the difference between agreement and contract. You know that when the agreement become enforceable, it will become contract. So void agreement means an agreement which is not enforceable by law. It's just an agreement, but again, which is not enforceable. We cannot claim in court. Such agreements all become void agreement. And void contract ceases to be enforceable by law. Contract was a valid contract at its inception, but later time it become void, or which is not possible to enforceable at court. So such contracts are called void contracts. To see some of the differences here, it's not enforceable by law from the beginning. Agreements ಅನ್ನು ಏನು ಮಾಡಿಕೊಂಡಿದ್ದಾರೆ, from the beginning itself it is not possible to enforceable. For example, an agreement to make some robbery is a void agreement, which is not enforceable by law and from the beginning itself. But void contract is valid when created but becomes void subsequently. As I told, is a valid. For example, the contract between A and B, but later time Mr. B become dead. In such situation, it was valid till the death of Mr. B and become void after the death of Mr. B. Does not create any legal rights or obligation at any time. So in this case, which will not create any rights or obligations, because it is not enforceable by law. ಯಾವುದೋ ಬ್ಯಾಂಕ್ ರಾಬರಿ ಮಾಡಲಿಕ್ಕೆ ಮಾಡಿಕೊಂಡಂತ ಅಗ್ರಿಮೆಂಟ್ಸ್, ಅದರಲ್ಲಿ ಯಾವ ಪಾರ್ಟಿಗಳಿಗೆ ಕೂಡ ರೈಟ್ಸ್ ಅಥವಾ ಜವಾಬ್ದಾರಿಗಳಂತ ಹೇಳಿರೋದಿಲ್ಲ. ಅದನ್ನ ಜವಾಬ್ದಾರಿಗಳನ್ನ ಫುಲ್ಫಿಲ್ ಮಾಡದೇ ಇದ್ರೆ ಕೋರ್ಟಿಗೆ ಹೋಗ್ಲಿಕ್ಕೆ ಸಹ ಆಗುದಿಲ್ಲ. But in case of void contract, binding on the parties still becomes void. For example, as we seen in the example, in case of contract between A and B, till the death of Mr. B, it's binding because it's binding on the parties. And that means till the death of Mr. B, the business parties have rights and obligations. But after the death of Mr. B, the rights and obligations ceases to exist. They cannot claim the rights in the court. So that is the difference between void agreement and void contract. Hope you understood the differences. And the second differences is voidable contract and void agreement. Of course, again here we are comparing one contract with one agreement. So voidable contract, as we seen in the previous slides, contract enforceable at the option of one or more of the parties but not at the option of others. Void agreement, an agreement which is not enforceable by law. It's agreement but it's contract. And again, voidable indicates it's optional to carry on the contract or to close the contract. If they want to close a contract, they can consider it as a void contract. If they want to carry the contract, it will become valid contract. But in case of agreement, it's very clear void agreements cannot be enforceable from its inception. ಯಾವಾಗ ಅಂತ ಅಗ್ರಿಮೆಂಟ್ ಅನ್ನು ಕ್ರಿಯೇಟ್ ಮಾಡ್ಕೊಳ್ತಾರೆ, ಆ ಕ್ರಿಯೇಟ್ ಮಾಡಿಕೊಂಡಂತ ಸಿಚುವೇಶನ್ಸ್ ಇಂದನೇ ಅಂತ ಅಗ್ರಿಮೆಂಟ್ಸ್ ಗಳನ್ನ ನಾವು ವ್ಯಾಲಿಡ್ ಅಂತ ಹೇಳಿ ಕನ್ಸಿಡರ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ. ಅದನ್ನ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎನ್ಫೋರ್ಸ್ ಮಾಡ್ಲಿಕ್ಕೆ. Let us see some of the differences between voidable contract and void agreement. So first point of difference is enforceability. Voidable contract is enforceable at the option of aggrieved party. Either they can continue the contract or they can close the contract, terminate the contract. It's based on the parties to the contract. Void agreement. So here, which is not enforceable by law, which is not in the hands of parties to contract. Next one, legal effect. Binding on the parties still become void. So till it become void, it was binding on the parties. There was rights and obligation on the parties to contract. After that, it will eliminate. But in case of void agreement, there is no such obligations. There is no legal effect on void agreement from its inception. Collateral agreements does not affect the collateral agreements. So collateral agreements means the agreement associated with the main contract. So it does not affect the collateral agreement. So which will not affect the further contract associated with the main contract. But in case void agreement affects collateral agreement. Breach of promises. Aggrieved party can claim relief if any one person fails to fulfill the contract. That particular situation is called as breach of promise, breach of contract. In such situation, to whom the loss incurred, that person is called as aggrieved party, and that person can claim the relief in court. But in this particular case, aggrieved party cannot get any damages. For example, so here for void agreement, we have considered an example of agreement to make some robbery. If any disputes in between the contracting parties, they cannot claim in the court because the agreement itself void. So for that reason, it cannot be aggrieved party. ಯಾರಿಗೆ ಲಾಸ್ ಆಗಿರ್ತದೆ ಅವರು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕ್ಲೈಮ್ ಮಾಡಲಿಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ. Because the basic purpose of contract itself is wrong. So that is the differences between voidable contract and void agreement. Hope you understood these terms. So let's have a small recap. In contract, we have classified on 3 bases: validity, creation and performance. Let's have a small quiz. An agreement which is not enforceable by law is valid contract, void contract, valid agreement, void agreement. Little bit confusing, but I'm sure you will get the answer. Yes, void agreement. For voidable contract, which of the following statement is true? Enforceable by law, enforceable at the option of aggrieved party, not enforceable by law, none of these. The answer is B. Enforceable at the option of aggrieved party. Voidable, able, that means at the option of parties. Which of the following is void in its inception? Void contract, void agreement, voidable contract, quasi contract. So the answer is void agreement. Contract in which both the parties have not performed their respective promises wholly. So it is executed contract, executory contract, partly executed contract, and void contract. Answer is B. Executory contract. They have not started the work yet, but yet to start the work. Obligation created by law based on the principles of equity, justice, and fairness. So this agreement or this contract is called as executed, executory contract, partly executed contract, or quasi contract. Yes, the answer is D. It's quasi contract, a special contract created by law. Hope you enjoyed the lecture. Thank you for watching and happy learning.